Advertisement done. So let's talk about the new Family and Medical Leave Act, its implications for townships, and just kind of give you a big 10,000-foot overview of what this thing is. In very broad strokes, HF2, which is what you will often hear called the Family and Medical Leave Act, is a big new law that was passed this session, signed into law May 25th, 2023, became Session Law Chapter 59. In very broad strokes, the idea seems to have been something like creating an unemployment insurance scheme, except for family and medical leave. They drew a lot from the unemployment insurance scheme in drafting this thing. Now, its full formal description is a mouthful. I have put it up on your screen so you can share a bit of my pain in how I have been picking through this monstrosity. An act relating to state government, providing for paid family bonding and applicants' serious medical condition benefits, regulating and requiring certain employment leaves, authorizing income tax withholding, imposing taxes, authorizing penalties, classifying data, yada, yada, yada. Okay. Now, the first question that I always have when dealing with a new law, particularly new law relating to townships, is do we have to care about this? Because there are just tons of laws out there that are huge and detailed and thorough and burdensome and bind local governments in all sorts of ways. But it's not that unusual for the legislature to exempt us. Obviously, we are the smallest, most direct form of government. We have the lowest lift capacity in terms of our administrative footprint here. So it's not that unusual for the legislature to take us into consideration and cut us out of the thing. Unfortunately, they declined to do that in this particular case. Now, today, when I'm referencing particular sections of the law, I'm referencing so Chapter 268B is a chapter that will be created by this law, or I guess has been. So this is how it is phrased within Chapter 59 of the session laws. Okay, so they've codified this thing kind of at
Hey, Graham.
Hello?
Are we supposed to be seeing your screen?
Yes.
Because I don't think any of us are seeing your screen.
All right. Well, that's not great. Let me see if I can fix this. All righty.
And now we can see it.
Now we see it.
Well, folks, I am sorry about that. Had a bit of technical difficulties this morning. I am working on a different computer than usual. So, all right. Well, anyway, so here is what you were supposed to have been seeing. 10 law review stuff. Here's our list of topics. And then this is sort of the intro to the Family and Medical Leave Act that I was just talking about. So here is where we were. So Minnesota statute 268B.01, subdivision 18 and subdivision 17 are sort of how the legislature has decided to include us in this thing. We've got a quotation here from subdivision 18 in parens 3. Employer means any municipality or local government entity, including but not limited to, and then there's a long list. That's why I've got the ellipses there, a town. So we are unequivocally included in this thing, unfortunately. Now, employee is also, of course, something we're going to have to pay attention to here. So employee means an individual who performs services of whatever nature for an employer. And then there are a couple of carve-outs. So federal employees don't count for us if you're actually an employee of the United States government. You don't count as an employee under this chapter, entertainingly. The other interesting one is that seasonal employees don't count, and there's a relatively detailed definition of what a seasonal employee is. So that could potentially be relevant for our townships here, but just sort of kind of giving you a brief overview here. Okay, so now that we know that this thing actually applies to us, the question is, what do we have to do? Or so what is this thing? So Chapter 59, session laws, that is what is actually passed, is divided into 3 major articles. The first of them is the meat of the thing. So this is the article that establishes the substance of a new family and medical benefit insurance program under Chapter 268B. But, you know, at least for legal trivia purposes, there are these 2 other articles that also have been passed here. So the second provides the way this thing is supposed to interact with benefit programs, and the third is the portion that actually, for the most part, appropriates the money necessary for the government put together the administrative architecture of this thing. But of course, that's not really what we're interested in here. We're interested in brass tacks. So what are our new obligations under this scheme? And there are a bunch. I mean, this law is pretty big. We're going to be developing more specialist training over time, but I thought we would focus on the practical side for this morning. So these are kind of the big ticket items, at least as I see them, together with the relevant citations. So we have new requirements to make quarterly wage reports. They decided in their infinite wisdom that these things would be done exclusively by electronic means. There's actually a portion in Minnesota Statute 268B.12 that says you have to do this by electronic means. And then there are penalties that apply if that doesn't happen. So failing to do it results in a late fee of $10 per employee, though that can be waived under certain circumstances. For example, if they give you a written demand, and they can send that electronically, by the way. If they give you a written demand and you get it to them within 30 days, that's supposed to be withdrawn. If information is missing, if information is in error, that there's supposed to be an administrative service fee that's going to be imposed on employers, including potentially townships. Well, not including potentially, we are defined as an employer, so it would apply to us as well. This requirement is come into force July 1, 2024. So we're going to need to start paying attention to that next summer. The other big ticket item, we need to start paying a yearly premium on employee taxable wages. So this begins January 1, 2026. So we're going to be paying into accounts roughly analogous to unemployment insurance is sort of the idea, it seems, on this thing. Once again, the obligation is to pay quarterly. And there is, relevant to us, small employers get a bit of a break on this. Now the language comes from 268B.14, and subdivision 5 is what's called the small business wage exclusion, but of course it's phrased in terms of how many employees you have rather than requiring you to be a business specifically. The language is for employers with fewer than 30 employees, the amount of wages upon which quarterly employee premium is required is reduced by the premium rate to be paid by the employer multiplied by the lesser of $12,500 multiplied by the number of employees, or $120,000. So we can't, as a result of this, end up with a premium that is less than zero. So we can reduce it to zero, but that's as far as it goes. And so I think that's going to be, I'm not aware of any townships that have got more than 30 employees. There may be a few of you out there, but I think that's going to apply to the vast majority of us that happen to have any employees. Now, the other big kind of requirements here are record keeping. So MinStat 268B.21. The Department of Economic Deed, so they get to set rules on record keeping. But this statute, 268B.21, tells us that we have to keep records for not less than 4 years, and they're allowed to conduct audits as necessary or investigations as necessary to effectuate the purposes of this chapter, is the phrase that this thing says. And then, of course, we have to post notice as well. Minnesota Statute 268B.26, we have to post notices to inform employees of the new rights and benefits. And the standard here is that it must be, quote, posted in a conspicuous place. Now, that notice is supposed to be prepared by the commissioner of deed. So it's not something that we're going to have to whip up ourselves, but that is going to be a requirement that's going to be imposed upon us. So this one is effective July 1, 2025. The one we were talking about earlier there is effective July 1, 2024. So these dates are dates that we're going to keep in mind. And of course, as things get closer, we're going to be doing more detailed trainings on this. Okay. Now, of course, this also creates for employees certain new potentially enforceable rights. There are a few here, and there are a few that I think that are worth bringing to your attention. So there's a right to leave now. under certain circumstances. So that maximum length of that leave is set by Chapter 268B.04 Subdivision 5. It is the lesser of 12 weeks, or 12 weeks minus the number of weeks within the same benefit year that the applicant has received benefit for stuff like bonding, safety leave, family care, or qualifying agency plus 8 weeks. The total number of weeks that an applicant may take benefits in a single benefit year for bonding, safety leave, family care, qualifying exigency is the lesser of 12 weeks, or 12 weeks minus the number of weeks the same benefit year that the applicant received benefits for serious health condition plus 8 weeks. So that's a new potential right that's sort of been created by this scheme for employees. There are certain limitations in terms of who qualifies, but big ticket items, that's kind of what's gonna. That's the number that I would want to be keeping in mind here. There are additional protections related to sort of creating or preserving this right in a practical sense too. So now retaliation on the basis of requesting these sorts of leave is prohibited. That's Chapter 268B.09, Subdivision 1. You can't discipline somebody, you can't fire them, you can't penalize or interfere with requests for leave. There's a right to continued insurance coverage, 268B.09, Subdivision 5. If you were getting insurance through your employer before, you can't cancel it now and during one of these leaves. And then 268B.09, Subdivision 6, there's a right to reinstatement, something like equivalent to the old job now. There are provisions made for what happens if we have to restructure during the meantime. But that is potentially a pretty burdensome right for us as employers. Now, of course, what happens if we ignore this? That's also one of the big 10,000 foot questions that we are always interested in whenever we see a new statutory scheme, and there are certain enforcement mechanisms that have been created in this new scheme as well. So starting with stuff like correction letters, Department of Labor and Industry has the authority to issue sort of compliance letters, say, issue penalties. There are appeal provisions. These things are fairly tight. We've got a deadline of about 15 days from the time that we get one of these things to challenge it, and then we can kind of move up through the hearing and appeals process. But that is one mechanism through which the state has chosen to create enforcement provisions on this thing. Another big one is Minnesota Statute Chapter 268B.19, which is sort of forbids, quote, employer misconduct is the term that it uses here. And so that is, it provides certain monetary penalties if employers help employees fraudulently get benefits, or if they fraudulently attempt to deny benefits. And that is so if you're actively misrepresenting something, or if you're making representations without knowledge as to their truth or falsity, with an intent to either wrongfully deny or wrongfully gain benefits for a particular individual, you can be subject to certain monetary penalties, which is measured by the entitlement that you were denying or wrongfully giving under certain circumstances. So there definitely are teeth to this thing. But of course, this thing is quite complicated. It's pretty big, and of course, as with any statutory scheme, particularly one that's a couple of years out, this could be subject to revision. This could be subject to change potentially before some of this stuff starts going into effect. So I thought the biggest and best idea was just kind of give you a 10,000 foot picture of new rights, new obligations. And then as things get closer, we'll kind of talk more about process and more about sort of detailed obligations as they come up. So I see we've gotten some chats here. Do we only report once we have an employee who uses leave? No, so we have reporting requirements for wages that are quarterly. So if we've got an employee, we're supposed to be reporting this thing quarterly, and it's supposed to be by electronic means. So that's a relatively harsh requirement, particularly for some of our townships who may not even have computers yet. We're going to have to get that one figured out. We sort of all knew, I think, on some level that this day was eventually going to come, that eventually we were going to end with certain programs just flat requiring us to adopt these technologies. So it's finally come, I suppose. So yes, we're supposed to report on a quarterly basis. Does anybody else have any other questions?
And any questions at all? If you have a question for Graham, if you have a question for Lori or Nicole, one of our trainers, or for myself, please, now's the time to speak up. We'd love to answer that for you. Graham, you can stop sharing your screen if you'd like.
Nope.
Thank you. Nice presentation.
Just a moment. There we go. All right. Sorry about that, folks.
No problem. No problem. Well, not seeing any questions at all. I assume everyone's doing okay, so that's great. I do thank you all for attending and this Township Tuesday. Tell your other fellow officers. I keep losing my voice. And we'd love to have more people on here so that we can spread the news to more people and offer more assistance as needed. And so, but thank you all for attending, and we look forward to seeing you next Township Tuesday. Take care, guys.
Thanks, folks.
Jeff, there was one more question on the chat that just popped up.
Okay.
Something about reporting if they don't have an employee, I think.
Yes. All right. Let me, I believe the answer is no, but let me lay my hands on the actual codification here before I go opening my mouth. All right. Just a moment here. Thanks, folks. Dealing with a different computer, which is which does not have my notes on it. So let's. All right. Employee and all seasonal employees covered employment required on a calendar quarter basis. So I believe the answer is no.
Okay. Good. Thanks, Graham. All right. Again, if there's any other questions that people have, please let us know. And you can talk to one of the attorneys, give them a call, or talk to myself or our trainers, and we'd love to help you out. So hope you all didn't have my video on. Hope you all have a great rest of your week, and we'll talk to you again real soon. Take care.
Graham, could you hang on for a second with me? And I have a quick question. I think Jeff, you had thought he might be able to answer it for me.
Yes.
Thank you.
Yes.
Sure. Happy to.
The question I had, Graham, was that I was at another meeting for Region 5 Development Commission, and they had talked about the end of the pandemic and using Zoom to conduct public meetings and the ability to participate in a voting perspective. So if you're not available at a public place, you're not allowed to vote at a township meeting, for example, or a Region 5, whatever the case may be. You know, you wouldn't be allowed to be in your car or at your house. You'd have to be in a public setting of some sort, and that wasn't really identified. I got to read the statute, but is that something that you are aware of? Jeff seemed to know what that it all was happening, of course, but
yeah. So here, hang on. Let me share my screen here. So there are a couple of relevant statutes. Let's see. Can everybody actually see this one this time?
Yeah. Thank you.
Okay, so we've got two that are working with new computers. All right. Okay, so there we go. Getting that bar out of my own way, and so there are two that are potentially relevant here. So one of the ones that we had been using fairly regularly during the pandemic was this guy right here, Minnesota Statute 13D.021, which a meeting governed by this section, that is the open meeting law in general, may be conducted by telephone so long as the following conditions are met. So you have to have this determination that because of a pandemic or emergency declared under Chapter 12, an in-person meeting or meeting conducted that is not practical or prudent. That is not the only way to get to a remote meeting. There is this other beast right here, which is 13D.02. So in this one, you can potentially still conduct your meetings by remote, but you do have to sort of go through these steps, and that includes, by the way, voting. But you do kind of have to go through all of these steps. So everybody has to be able to hear and see one another, and they have to be able to hear and see all the discussion. People who are present at the regular meeting location of the body have to be able to see everything. One of our members has to be physically present. Votes have to be done by roll call so that everybody can be nice and identified. And then this is the real difficulty with the non-pandemic one related to trying to do this thing from your car. So each location at which a member of the body is present has to be open and accessible to the public. So if you want to do these things primarily by Zoom, you can do it. You just have to let people be sort of where it is that you are. Of course, there are exceptions to that. So if you don't do it more than 3 times in a calendar year, and you have a specific doctor's note for you, then you don't have to make your particular place open to the public. If you're serving in the military and you're on a required drill or active duty, something like that, then your specific area doesn't have to be open to the public. But frankly, you do very clearly count as participating in quorum here. So this is subdivision 2. You are considered present, legally speaking. You get to vote. You get to quorum is present, the whole 9 yards. So there are means to do this if that is something that you are interested in. So you can't do it by phone, of course, because we have that language at the beginning of 13D.02 that talks about people have to be able to see you. Right.
Well, my other concern is that it's sort of silent on where the public place is. So can you actually be in another state in a public place?
I would say yes.
Like a library?
You could be at a public library. You have to give people notice where you're going to be. That people have to have the ability
Right.
to. But it's silent in terms of the location. So so long as you're abiding by the other requirements in 13D.02, if you're in a public library in Arizona or whatever,
Exactly.
I would say that complies.
So the public notice, can that be a posting, or does it need to be in your publication of record?
Interesting question. I believe that one can be just a posting, but
Okay.
I hate practicing law from memory, so
No, that's okay.
It's
It's just, I forgot a couple of the requirements, so I'm glad you ran through them again. I forgot about it's just some of the requirements there were in there.
Well, it's definitely potentially a touchy thing, and you want to be careful with it because, of course, if you screw it up, then you're not present for quorum purposes. And 36703 sub 7 says that they get to say, all right, you're not attending, therefore, goodbye.
Yep.
So you want to be careful with that kind of stuff.
Well, yeah, if posting is all it is, they're all reasonably easy. Just costs a little money to put in a newspaper, but that's all right too, if need be.
Give me a call after this. I'll open the statute book. I'm reasonably sure that it's posting, but I want to actually look that one up before I give you a formal answer, if that's okay.
No, perfectly fine. In fact, you and I were supposed to get together on something else a while back, and I forgot to get with you. But I'll try to remember what that is, and we'll set up some time when you have a little bit more available. So I'll pull the statutes up too. So thank you very much for the initial stuff.
Always happy to help.
Very good. Thank you, sir.
All right, folks.
We're out of here, I think. Thank you.
I guess no. We have been told that a township legal seminar that the person could be in a hotel room but need to let people in if they wanted to attend. I would say that if you're in your house, if you're in if you're in the cabana by the pool, whatever it is, so you saw the operative language there, open and available to the public. So if it's your private house and you open it and make it available to the public, I'm not sure I'd want to do that personally, but your communities better than I do, and if it's a thing that works for you, I would say that complies with that language. If you're in a hotel, that one's a bit more interesting because, of course, you're at a private place that you don't entirely control. I think likely that's fine. So long as a member of the public can just sort of wander in off the street, they know where you are, they can go find you. Difficulty would be if you're in a place that sort of requires like a key or a key card in order to get to your room in the first place. That could be problematic. I would be cautious about that one. So long as you had buy-in from whatever hotel and they were willing to just like put up that little sign, say, hey, this is where we are. You can come in if you're coming in for that meeting. I would say you're fine. I would not bet my own rear end on it if we're talking about a locked front door type situation. But of course, I'm not your dad. I don't get to tell you what kind of risks you want to run. So, Pat, did I see you? Your mouth moving there? You're muted. Secret knock to enter. Yeah, that probably worked too. All right, folks. Well, if nobody else has any other questions, thank you very much for your time and your attention. And have a nice morning. Please feel free to give me a call if you've got any follow-up questions, or if, anything like that. All right. Have a good morning, folks.